Good morning. Hope everyone's doing all right. So now we are going to have a look through Wayfarer's opposition to Lively's motion in limine. I haven't read this yet. I skimmed. It looks interesting. I can't wait to see some of the arguments. Let's begin. Okay. Pursuant to the court's case management plan and scheduling order as amended on March 26th, 2026, defendants Wayfarer, blah, 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 we know who they are now, Wayfarer, Into This Movie, and Tag, respectfully submit this omnibus memorandum of law in opposition to Lively's motion in limine. Okay. Before I start, there may be some background noise because it's a weekend and my house is full, so sorry about that. But anyway, let's hope we're all strapped in for this. Okay, so the first one, Lively was seeking to exclude any evidence of her reputation before the alleged smear campaign, basically giving the jury absolutely nothing to compare, like what people thought of her before and what they think of her, now after. She just wanted the jury to, make a finding of a trust me, bro, that she was smeared. All right. Opposition to plaintiff motion in limine number 1. Defendants should be permitted to present evidence of Lively's reputation before the alleged smear campaign. Plaintiff Blake Lively's motion in limine number 1 flies in the face of a well-entrenched law. Lively placed her reputation squarely at issue by seeking over $290 million in harm to her personal and professional reputation and livelihood. She did. Nevertheless, Lively seeks to exclude evidence just demonstrating that prior to the alleged smear campaign that purportedly damaged her reputation, she already had a well-earned and well-publicized reputation as, among other things, a mean girl and tone deaf. Well-earned. This is going to be funny. I do know that. It is going to be funny. Lively specifically identifies 5 press articles and others like them as excludable. So that's the slavery stuff, the cute hats and everything, the transgender slur, so on and so forth. The preserve. Oh, and her plantation wedding, that's it. Each painted Lively as tone deaf and a mean girl. Lively, understandably, would prefer to keep this evidence from the jury, arguing that the articles portraying her as tone deaf mean girl are hearsay, inadmissible character evidence, improper lay opinion, and unduly prejudicial. It's definitely prejudicial. In the sense that, jury are not going to like it. The evidence plaintiff seeks to exclude is not hearsay, and it is not being offered for the truth of the matter asserted, to wit, that Lively is a mean girl, bully, or tone deaf, or something similar. And in any event, the hearsay rule expressly carves out character evidence. In fact, courts recognize that reputation can only be proven with hearsay. Yes. Lively's other grounds for exclusion, lay opinion, and undue prejudice are equally frail. Rule 404 does not warrant exclusion of character evidence here, whereas here, a plaintiff placed his or her character directly at issue. Lively did just that when she sued for reputational harm, leaving the defense to prove, among other things, that her reputation was so tarnished it could not have been impugned or diminished by an alleged digital campaign by defendants. Finally, Lively's lay opinion argument hinges on the notion that defendants may not present evidence of Lively's pre-existing reputation because none of their experts opined on the impact to the public. The argument seems to be that absent expert testimony, the articles constitute lay opinion and based upon speculation and hearsay. Lively should not be permitted to cripple the defense by stripping defendants of evidence of Lively's pre-smear campaign reputation that would include her reputation was tarnished long before she stepped foot on the set of It Ends With Us. Evidence that is pivotal to negate causation. Yeah, that's a great argument. Articles and evidence establishing Lively's pre-existing reputation are not inadmissible hearsay or character evidence. Evidence of Lively's reputation prior to encountering defendants is not hearsay. Hearsay is a declarant's out-of-court statement offered in evidence to prove the truth of the matter asserted in the statement. And when they say it's not offered to prove the truth, they're not offering these articles to prove that, as proof that Lively is a mean girl or tone deaf. They are offering it as kind of evidence that her reputation actually wasn't that good before this alleged smear campaign. So, but it is not. When they say it's not to prove the truth of the matter, what they mean by that is they're not offering it to prove as proof that Lively is a mean girl. That's not what they're doing here. If the significance of an offered statement lies solely in the fact that it was made, no issue is raised as to the truth of anything asserted, and the statement is not hearsay. Evidence of Lively's pre-existing reputation is not being offered for the truth that she is a mean girl, bully, difficult to work with, or tone deaf, but to establish Lively's reputation prior to the alleged smear campaign, to show that defendants' alleged conduct did not cause further harm to her existing reputation. Even assuming the material that Lively seeks to exclude could be deemed hearsay, hearsay is admissible if it falls within an enumerated exception to the hearsay rule. It is universally recognized that reputation evidence must be based on hearsay. Accordingly, Rule 803 provides an exclusion to the hearsay rule for reputation among a person's associates or in the community concerning the person's character. Nor are the articles excludable as character evidence under Rule 404. First, defendants are not seeking to admit the articles as evidence to prove character, but rather for some other purpose, namely to rebut plaintiff's theory of reputational harm. My voice is already going. Media reports relating to Lively's reputation are also admissible under Rule 405B, which permits the introduction of opinion evidence, reputation evidence, and specific instances of conduct when the character of a person is an element of the claim or defense or is otherwise at issue, as in the case of a claim for damages due to reputational harm. A charge of defamation or libel commonly make damage to the plaintiff's reputation or character an essential element of the case and admissible under Federal Rule of Evidence 405B. All right. Although Lively's claim is nominally for retaliation, she is seeking the same reputational harm damages as recoverable for defamation and libel. Yes, she is. Thus, character evidence is admissible as an element of her reputational harm and lost profits damages. The probative value of evidence relating to Lively's reputation far outweighs its potential prejudice. Lively next invokes Rule 403 to argue that the articles and similar evidence are more prejudicial than probative. As noted, Lively opened the door to this evidence and made it highly relevant by putting her reputation at issue and forcing defendants to defend the allegations by, among other things, showing that they did not cause harm to her already tarnished reputation. A plaintiff's existing reputation is universally recognized as relevant to a claim for reputational harm. For instance, New York's pattern jury instruction recognizes the importance of a plaintiff's existing reputation in determining the appropriate damages award by instructing that a factor for the jury to consider is the plaintiff's standing in the community. So they're now relying on, jury instructions what Wayfarer are doing here are saying, look, judge, here, this jury instruction says this jury instruction says that. So they are kind of highlighting how how this is relevant and this kind of evidence is admissible. Such evidence is also admissible under the libel proof doctrine, which permits a defendant accused of causing reputational harm to show that the plaintiff is libel-proof because his or her reputation is already so badly tarnished that the plaintiff cannot be further injured by even false statements on the same subject. By way of example, while labeling a plaintiff as a murderer would ordinarily harm a plaintiff's reputation, calling Jeffrey Dahmer a murderer would not sully his reputation, which included a reputation as a murderer. Well, do you know what? I did not have seeing Jeffrey Dahmer in this case on my bingo card. Articles depicting Lively's pre-existing reputation are not lay opinion. Lively's final Hail Mary is that articles and similar publications establishing her existing reputation somehow constitute inadmissible lay opinion. Not so. A layperson is someone who testifies based on personal knowledge rather than specialized training. Lay opinion refers to an opinion or inference that a non-expert witness provides during their testimony. Rule 701 allows a lay witness to offer an opinion if three conditions are met. The opinion is rationally based on the witness's own perception. It helps the jury understand the testimony or determine a fact and does not rely on scientific, technical, or other specialized knowledge. Lively does not seek to exclude opinion testimony by a lay witness, but publications that demonstrate the state of Lively's reputation before the alleged smear campaign. Lively urges that there is no fact or expert opinion evidence establishing that Miss Lively carried out a negative reputation and that Lively carried a negative reputation and public perception prior to August 2024, and that defendants are relying on the existence of negative press, which constitutes lay opinion. Plaintiff deliberately misses the point. In contrast to the cases cited by plaintiff, defendants are not offering the articles to prove public perception, but only to compare her pre- and post-reputation to show whether the alleged smear campaign had a negative or indeed any effect on Lively's reputation. If not, Lively's claim for reputational harm damages fails. Defendants do not intend to call any witness to offer an opinion on public perception. The question is not whether the public perceived that Lively was a mean girl, bully, or tone deaf, but whether these allegations were widely circulated before Lively encountered Wayfarer. This is not lay opinion. That was really good. Really good. I think they'll get that in. But now we're going on to Vanzan. Opposition to plaintiff's motion in limine number 2. Defendants should be permitted to offer evidence concerning Lively's abuse of New York's legal system. There is no serious dispute that Lively used Vanzan Inc., a company through which she and her husband pay their personal employees, to file a sham lawsuit in New York State Court against 10 unidentified Doe defendants, nor that the purpose of filing this lawsuit, promptly dismissed without any defendant being served, was so that Lively could issue a pre-answer subpoena to Wayfarer's former publicist, Stephanie Jones, nor that the point of these shenanigans was to provide Jones with legal cover to turn over communications Jones had taken from Jennifer Abel's phone, nor that Lively filled out her CRD complaint with inflammatory snippets of these communications and then provided that complaint to the New York Times before she filed it, giving the paper the basis for its highly damaging December 2024 story about Baldoni. This outrageous misconduct is highly relevant to the issues that Lively has framed for trial. Lively has placed defendants' actions in this litigation squarely at issue. Yes, exactly. She plans to argue that defendants' litigation conduct, including their filing of counterclaims against Lively, was retaliation for Lively's protected conduct, which she defines to include her filing of this lawsuit. Defendants have moved to preclude Lively from offering such evidence at trial. However, if the court permits Lively to proceed on this theory, defendants will argue that their actions in this litigation were reasonable defensive measures. To support this argument, defendants will show that they knew from the moment the New York Times story broke that Lively had wrongfully obtained their publicist's confidential work product. This wrongful and damaging conduct by Lively was the background to defendants filing their counterclaims. This context tends to show that defendants' actions in this litigation were reasonable and proportionate defensive measures and not illegal retaliation. Separately, to the extent Lively is claiming damages to her reputation based on the manner in which defendants have litigated this case, including the filing of their counterclaims, defendants are entitled to present evidence of alternative causes for Lively's declining reputation. Her own aggressive litigation tactics, including the filing of a sham lawsuit against the make-believe Doe defendants just to obtain subpoena power, cannot be ignored as a factor that colours her current reputation and contributes to the diminishment of her fan base. Yeah, because everyone was pissed off with Vanzan. Everyone still is. Like, the outrage was palpable. So even some of her supporters up to that point were like, yeah, no, that's just dirty tactics. And this was all done before she filed the lawsuit. So, I mean, when we're talking about power, which harassment needs, there needs to be an imbalance of power. And we're talking about being a victim and being made to, like, be re-victimized, be being traumatized and then re-traumatized. When you've got the resources that you can file a sham lawsuit to skirt due process and strip others of their rights, then that's a big deal. People don't like that. Even if Lively had a genuinely good case with, some good evidence to back it up, people would still be pissed off with it. Think about it from this context, and I have been in Jen Abel's situation, in my own situation. So your data, everything about you, right? It's so private. It's so there is not much else in the world that is going to be more personal than your confidential data, communications, accounts, years of communications with, this phone contained communications with her partner, her parents. It wasn't just a work phone. And Stephanie Jones handed all of that to Lively because of this sham subpoena. And also, speaking as, one of the content creators who was, on the hook of one of Lively's underhand subpoenas, I know what it's like to feel that anxiety. It's like, oh my God, this person is going to get access to all my stuff. Because it doesn't just, and it didn't in Jen Abel's case, it does not just stay private. Lively's not going to take care of that and treat it like she would her own data. With Jen Abel's stuff, like Wayfarer is saying, you dumped it in the New York Times. And that was definitely the arguments that us content creators who filed motions on the docket were saying was, look, she's doxed so many people. She has put confidential information. And, like, it's one thing if you genuinely have a need. But once, as Lively said in her motion, in her motion in limine about Vanzan, is what she does with, information that she obtains via a subpoena is up to her. She can do whatever she wants with it once she's got it. There is no duty to treat it with care. There's no duty to keep it confidential. She can blast it publicly all she likes. And that is the terrifying thing. And she's now kind of set a blueprint now that how many people are now going to, use old defunct shell companies or set up companies even to pull a similar stunt. Because that's now possible. If you want to get some information on someone, Lively's just given everyone the roadmap to do that. And it pissed everyone off, regardless of what side you were on. In this case, it pissed many, 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 many people off. And then for the lawyers to be coming out going, it was just good lawyering. It was just aggressive lawyering. No. Us lawyers were all quite unanimous. We know that you don't do that. You don't do it. It's unethical. And if it's not illegal, it should be after this case because it's wrong. Right, now I've had my soapbox moment. Finally, the filing of the sham Vanzan lawsuit, an outright act of deceit against the court system, is also directly relevant to Lively's credibility and may be inquired into on cross-examination. Yes. The Second Circuit has recognised that evidence of other litigation may be appropriate for this purpose. Defendants do not plan to dwell on the Vanzan lawsuit and do not anticipate that it will occupy much trial time. This case is not like recourse systems, in which the court excluded evidence of other litigation completely unrelated to the transactions at issue in this case, and therefore irrelevant. Nor is it like in Regen Motors ignition switch litigation, in which the court explained that there was no evidence of intentional misconduct, but merely construing the concept of relevance too narrowly and thus withholding documents and materials that should have been turned over. And there was intentional misconduct. That's what Wayfarer was saying. Well, it's not like this case because there was intentional misconduct. Lively's intentional misconduct is self-evident, closely related to the events at issue and relevant both to the substantive issues to be decided by the jury and to Lively's credibility. Absolutely. Nicepool. Opposition to plaintiff's motion in limine. Number 3, Ryan Reynolds' creation of the Nicepool and Ladypool scenes to publicly shame Baldoni in Deadpool and Wolverine is relevant to Wayfarer's motive for engaging a crisis manager. Yes. Nicepool was a character created by Lively's husband, Ryan Reynolds, for the highly successful film Deadpool and Wolverine. The film was released in July 2024 on the cusp of the media frenzy over the Lively-Baldoni dispute. It was released like 2 weeks before It Ends With Us. Nicepool was a thinly disguised caricature of Baldoni who is skewered for his niceness and advocacy of women. Reynolds plays Nicepool, a Deadpool variant with a man bun, and Blake Lively voices Ladypool. In one scene, Nicepool appears before a flower shop, an obvious reference to Lively's character Lily Bloom, who is a florist in It Ends With Us. Ladypool shoots Nicepool multiple times, 17 actually, we counted them, like the 17-point list of demands, in front of the flower shop, and his head is eventually blown off. In another scene, Reynolds and Lively take a jab at Baldoni when Nicepool assures Deadpool, "It's okay, I identify as a feminist." Another insult to Baldoni occurs when Deadpool yells in a very out-of-context outburst. Yeah, it was out of context. "Where in God's name is the intimacy coordinator?" This is an obvious reference to Lively's allegation that Baldoni had improvised physical intimacy that had not been rehearsed, choreographed, or discussed with her, with no intimacy coordinator involved. It is impossible to watch the Nicepool segment of Deadpool and Wolverine and not understand why Baldoni and Wayfarer felt besieged in July 2024 and were compelled to bring in crisis management team. This is a good argument. Baldoni and Wayfarer's motive for engaging a crisis manager to plan a defensive public relations strategy is directly relevant to defeat Lively's core claim that defendants were acting in retaliation for her complaints of sexual harassment over a year earlier. Nevertheless, or perhaps for precisely this reason, plaintiff seeks to exclude this very public attack on Baldoni and Wayfarer on the grounds that this court has already found the footage irrelevant and therefore the law of the case doctrine mandates its preclusion. Plaintiff glosses over both the fact that the court's findings related to the malice element of the now dismissed defamation claim against Reynolds, not Lively's claims against Wayfarer defendants, and that the application of the law of the case doctrine, even if it is applicable, is discretionary. And this is what I said when I read the motion in limine from Lively to exclude Nicepool, was because she was saying, well, it's not relevant. The court said it wasn't relevant. And I was like, hold on a minute, not quite. They said it wasn't relevant for the big in terms of the defamation case against Ryan Reynolds because satire is protected activity. Well, it's protected free speech. But also, there was a motion to compel, I think, from Marvel, in which Judge Lyman specifically said, it's not relevant, and Lively quoted that. But no, it was no longer relevant because, the cause of action that the discovery was being sought for was dismissed, i.e., the defamation claim against Reynolds. So in that context, it wasn't relevant. But Judge Lyman never ever actually said that it wasn't relevant at all to any of the causes of action against any defendants, just the defamation cause of action against Brian Reynolds, in that it didn't prove malice. So Lively relies on a footnote in the court's order dismissing Wayfarer's defamation claim against Reynolds for failure to plead malice, and a post-dismissal order granting third-party Marvel Entertainment motion to quash a subpoena seeking confidential business records. In the first order, the court found that Wayfarer's claim that Reynolds created Nicepool to mock Baldoni was a protected opinion, and therefore insufficient to establish the malice required for defamation. The court denying discovery from Marvel also relates to Wayfarer's dismissed defamation claim against Reynolds. Yes. Neither order found that evidence relating to Nicepool was irrelevant to Wayfarer's defense to Lively's claims. Yes. That the engagement of a crisis manager to formulate defensive public relations strategy not to retaliate for Lively's complaints of harassment over a year later. Yes. Nor does the law of the case doctrine advance Lively's cause. The doctrine is limited to issues actually determined. Questions that have not been decided do not become the law of the case merely because they could have been decided. As noted, the court has not decided that Nicepool is irrelevant to Lively's retaliation claims, i.e. whether the crisis management plan was in retaliation or a defensive measure to counter Lively and Reynolds' very public attacks on Baldoni and Wayfarer. Exactly. Furthermore, application of the doctrine is discretionary and does not limit a court's power to reconsider its own decisions prior to final judgment. A ruling on the relevance of Nicepool in the context of a third-party subpoena or as evidence of malice in defamation against Reynolds is a pre-trial evidentiary ruling which can be revisited. Yeah. Even assuming there is some outer limit on a district court's discretion to revisit evidentiary rulings, it is clear that pre-trial evidentiary rulings may be revisited where no prejudice accrues to the party that had previously thought it had secured a favourable ruling from the district court. Defendant's opposition to plaintiff's motion in limine number 4, evidence about Lively's and Ryan Reynolds' net worth and financial status is relevant to Lively's power broker theory. Exactly. Now, this Michael Robbins, when I went through his the Dalbert motion for him, like he was literally like, oh, but Steve Sarowitz, and he was like, oh, but people can have money and power. And I literally said in the video, and he was talking about Steve Sarowitz, and I was like, what? And Lively and Reynolds don't also have this money, power, resources? I mean, she was able to get Sony, and WME to act as her personal trained chimps. So how does she not have power? And there is testimony for some of the cast as well, and the side pieces to the cast, like Colleen Hoover, who admitted that she unfollowed Baldoni because Lively asked her to. So, and in that moment, like I initially, when I read through the motion in limine, which I did first, I was like, okay, their net worth, it's not really relevant. But when I read Michael Robbins' the Dalbert motion to exclude Michael Robbins, and there's all these references to power broker, and the theory that Steve Sarowitz had more power than Lively and Reynolds, and I was like, oh, actually, maybe their net worth now does become relevant, and I think this is what Wayfarer are about to go and say. Okay, defendant's opposition, right, power broker thing, right. Defendant seeks to exclude evidence of Lively and her husband's net worth and financial status. At first blush, plaintiff's net worth would seem irrelevant, and it did. Here, however, Lively's own expert, Michael Robbins, has opined in his report and deposition testimony about power imbalances in the film industry, which allow one party to exert substantial leverage over the less powerful party. And that, don't forget, power imbalance is important for the harassment as well, which she's got to say, well, I have a reasonable belief that I was harassed. And when, in terms of harassment claims, well, or her concerns of being sexually harassed, the one element is that there was a power imbalance. Initially, Robbins provided this opinion as to Steve Sarowitz, Wayfarer's financier, arguing that his wealth was relevant to show the balance of power between Lively and Wayfarer/Baldoni. When asked about how Ryan Reynolds' wealth and status as a power broker affected the Wayfarer-Lively relationship, he either could not or would not answer. In any event, Lively's own expert has opined that in connection with the entertainment industry, a party's wealth manifests in his or her level of power and is relevant to explain the dynamics between the plaintiff and the defendant. So she's put it at issue herself. Through her expert, she has put wealth status and net worth at issue. Lively, through her husband's state as an A-list star. Don't say that she's an A-list star. Through her husband's status as an A-list star and director, coupled with his vast resources, tends to show why Sony, WME, which at Reynolds' urging dropped Baldoni and Wayfarer's clients and even defendants, were lined up behind Lively and were loath to stand up to even Lively's most outrageous demands. It also tends to negate any argument by Lively that the wealth of Wayfarer's financier Steve Sarowitz somehow created a power imbalance between Wayfarer and Lively. Simply put, plaintiff put her and Reynolds' net worth at issue. Yes, she did. She has. If Robbins testifies on the power imbalance, the Reynolds family net worth becomes relevant. Yes. Further, apart from net worth, evidence of Lively's finances is directly relevant to her claim for hundreds of millions of dollars in damages allegedly caused by the purported smear campaign, including lost employment opportunities and profits. Evidence of Lively's income from these sources before the alleged smear campaign is critical to determine whether she in fact suffered losses in the form of diminished income and revenue. Also, Lively typically does not accept acting opportunities which conflict with Reynolds' acting schedule, particularly when he is able to garner a higher income for his movies than she can. Their income is therefore relevant. Yes. Absolutely. Surely Lively understands the importance of this evidence not only to the defense, but to her own ability to prove her alleged damages. Yeah. Finally, plaintiff will inevitably point to Wayfarer's motion in limine to exclude evidence of Steve Saueritz's wealth and net worth. However, Saueritz is in a very different position. In contrast to Lively, Saueritz is no longer a party and his net worth is not relevant to a determination of punitive damages or any other issue relevant to Lively's claims. But they will still, I think, if they're going to agree that Lively and Reynolds' net worth is fair game, I think they will say, well, so is Sauritz's, because Wayfarer and he was the financier of the movie. In his own deposition, he says, well, I paid for Lively, she can write me a check. Apart from the fact that I paid for the movie, yeah, I guess I am non-essential. And and he was part of this purely because of his finances. So whilst Baldoni is a co-founder of Wayfarer, and he was the actor, the director, and he also owned the rights to adapt the book. Steve Sarowitz, though, is part of Wayfarer, important part of Wayfarer, and specifically in terms of he provides the finance. So I do think, whilst I don't love this, but this is litigation and this is how it goes, I think that Steve Saueritz's finances and net worth will also still be relevant. But that's my opinion. Okay. Opposition to plaintiff's motion in limine number 5. Defendant should be permitted to use internal Sony communications to rebut Lively's trial arguments. I mean, absolutely. Absolutely. Because they show what Sony's a big company, huge company in terms of the entertainment industry. So they show what they thought it was like working with her. They show that, her reputation wasn't as stellar with Sony as Lively is trying to say it was. Okay. The court should deny Lively's blanket motion to preclude defendants from offering internal Sony communications. Lively primarily objects on hearsay grounds, but defendants will offer these communications for the non-hearsay purpose of rebutting Lively's claim that her allegedly good reputation within the movie industry was tarnished by defendants' alleged retaliation following the premiere of the film. In other words, defendants will offer these communications not for their truth, but to show that Sony executives expressed strong negative views about her. Defendants will also offer these communications to rebut Lively's argument that it was not her threats and use of leverage, but her strong relationship with Sony that led Sony to agree to her demands, a crucial question at trial in which the jury will have to determine whether defendants' actions were illegal retaliation or reasonable defensive measures. Lively plans to ask the jury for tens of millions of dollars in damages based on her allegation that defendants' actions following the premiere of the film tarnished her previously sterling reputation. But the evidence will show that Lively's reputation at Sony Pictures, one of the big 5 studios, was already in the ditch. Was already in the ditch as the direct result of her appalling behaviour during the making of the film. This included her insistence on taking control of the movie, her insistence on excluding Baldoni from the premiere, and her refusal to promote the movie unless her demands were met. The negative views of Lively expressed by top-level Sony executives are highly probative on this point. Sanford Panich is the president of Sony Motion Picture Group. In a March 11, 2024 message exchange with Ange Giannetti, and here comes the PR bit, with Ange Giannetti, a Sony production executive, Panich expressed dismay that Lively was doing her own cut of the movie, asked how Sony could control her creative control. Yeah, because Lively said that she, that Sony took the film from Baldoni and asked her to continue with it. That directly contradicts The fact they were like, "Oh my god, she's taken over. What can we do to stop her?" Sony was saying that. It contradicts Lively's email to Sarah Rule saying, "Yeah, and the production company took the film from the director and gave it to me to finish." Panage expressed dismay that Lively was doing her own cut of the movie, asked how Sony could control her creative control, and then described Lively as a terrorist. Giannetti, another senior executive, responded respectfully, "There is no process that works for her. There isn't. What is important is that we have a baseline so we know. You can tell her everything, include her in everything, and it still does not hold." Then on June 19th, 2024, Panage expressed shock that Wayfarer had given in to Lively's demands, saying, and they quote, "I can't believe they caved on the producer credit for her. This is truly insanity." And when Giannetti told Panage that Lively was now demanding that Wayfarer remove a film by Justin Baldoni from the credits, Panage shot back, "I don't want us to ask them to do that for her. She can ask herself. We've bent over backwards enough. This is getting to the point of absurdity." These communications suggest that these key executives, the people with the power to approve or kill a movie idea and veto casting, might hesitate to work with Lively again in the future. They suggest, in short, that Lively had a bad reputation, at least among the people who mattered at Sony. And all of this was months before defendants supposedly set out to destroy Lively's career in retaliation for her claims of harassment. Exactly. Wow, this is a really important point too. Given the consolidation of the movie industry, Sony is a hugely important data point, to say nothing of the fact that Josh Greenstein, at the time co-president of Sony Pictures and aware of the situation with Lively, is now co-chair of Paramount Pictures, one of the other big five movie industries. Moreover, these communications are not being offered for the truth and therefore are not hearsay. For example, they should not be used to show that Lively was in fact a terrorist, as Panage described her, or to show that that there was no process that works for her, as Giannetti complained. Rather, they would be admitted to show that people who mattered at Sony vehemently expressed these negative views of her long before the film premiere, and would be used to undermine the conclusion offered by Lively's experts that Lively's reputation was good in the industry before defendants allegedly destroyed it. Messages showing the frustration and dismay that Sony executives felt as Lively pushed to take control of the movie are also admissible under Rule 803.3 to rebut Lively's anticipated argument that she had a strong relationship with Sony, that in assuming various roles and greater control, she was simply following Sony's wishes, and that Sony gladly acceded to her requests. Defendants will counter this argument by offering Sony's contemporaneous internal communications to show that Sony executives were given in to Lively's threat, most notably her threat not to promote the film if her demands were not met. This context is relevant to show that defendants took reasonable defensive actions against Lively's scorched earth power grab and were not retaliating against her because of her fully resolved complaints of sexual harassment from over a year earlier. At minimum, the admissibility of the internal Sony communications should not be resolved on a blanket basis, but should be reserved until specific exhibits are offered at trial. As this court has explained, the trial court should exclude evidence on a motion in limine only when the evidence is clearly inadmissible on all potential grounds. Resolution of Lively's motion will require consideration of the evidence and arguments offered by Lively at trial and the particular exhibits or portions of exhibits offered by defendants. And just quickly say, Lively will probably, she's saying, well, the messages are incomplete, right? That's as far as Josh Greenstein's messages, but the Sanford Panage and Ange Giannetti ones are not, she's not alleged that they are incomplete. And Ange Giannetti is a trial witness. So I can't remember if she's deposition or live trial. But she will, as part, if she's deposition, she can be asked about these text messages. So they can testify to that. Lively's motion will require consideration of the evidence and arguments offered by Lively at trial and the particular exhibits or portions of exhibits offered by defendants. The court should therefore reserve judgment on the motion until trial, when admission of particular pieces of evidence is in an appropriate factual context. Footnote here. Lively separately argues that certain message chains recovered from Josh Greenstein's phone should be excluded because they do not contain both sides of the conversation. However, the fact that these message chains are incomplete does not, without more, make them misleading or unintelligible. If Lively has specific concerns about specific exhibits, they can be raised during trial. Yes, and I think I said in response to reading Lively's request for this in motion in limine, that would apply then to Jen Abel, and the Jen Abel messages that she put into the CRD, into every complaint, into the New York Times. Some of them are missing and incomplete. Wayfarer did a side-by-side demonstration of Lively's version and then their own version, which showed messages had been cut. So, that argument applies there too. Opposition to plaintiff's motion in limine number 6, defendants should be permitted to respond to Lively's argument that the defense in this litigation constitutes retaliation by offering testimony concerning the impact this litigation has had on them. Okay. Lively has taken the position throughout these proceedings that defendants' actions in this litigation are a continuation of defendants' retaliation against her for complaining about sexual harassment. As noted, defendants have moved to exclude this evidence. However, if the court permits Lively to argue to the jury that defendants' litigation of this case constitutes retaliation, then defendants must be permitted to put their actions in context by offering limited testimony concerning the effect that Lively's prosecution of this litigation has had on them. Basic fairness demands no less. For example, if Lively is permitted to argue that the claims defendants filed against her were retaliation for Lively's complaints of sexual harassment, then defendants must be permitted to explain that the accusations Lively levelled against them in this lawsuit affected them personally and professionally and called for a proportionate response. Contrary to Lively's suggestion, defendants do not plan to offer testimony concerning specific incidents, such as encounters with process servers during the January 2024 wildfires or concerning threats received as a result of this litigation. Nor would defendants offer evidence concerning the consequences which may befall them in the event of an adverse judgment. Rather, if Lively is permitted to open the door to this subject, defendants will offer brief, general testimony concerning the impact of this litigation and the reasons they felt compelled to put on a robust defense. Opposition to plaintiff's motion in limine number 7, defendants should be allowed to introduce Lively's own statements for impeachment purposes and to show the common practice of using public relations statement by the parties and their counsel to shape public opinion. So Lively doesn't want, because everyone picked up on it, is the dragon emoji for a start. I don't know if Wayfarer are kind of aware of that, but that was picked up. But also Sigrid McCauley changing her stance. In January it was all about sexual harassment. Now, as soon as the sexual harassment claims were dismissed at the start of April, it's always been about retaliation. And they're going to want to show this contradiction. Lively seeks to exclude her personal statements and those of her counsel relating to the case related in response to the court's ruling on defendants' dispositive motions. In the first instance, these public statements by Lively's counsel, Michael Gottlieb, and Sigrid McCauley, a lawyer apparently engaged to handle public relations, are crafted to sway public opinion in Lively's favour and may have the effect of tainting the jury pool. The opening sentence in Mr. Gottlieb's official statement is a gratuitous swipe at Wayfarer's counsel. Yeah. It is completely unsurprising that Brian Friedman, this is a quote now, it is completely unsurprising that Brian Friedman does not understand the court's actual ruling. He didn't even argue the summary judgment motion he's now spinning, had to bring in another law firm for the trial, and just last week was reprimanded by the court for having filed legally frivolous claims. Gottlieb further states, the fact that Brian Friedman is claiming exoneration based on legal technicalities while facing trial next month tells you everything you need to know. This personal attack on counsel is equal to or worse than anything for which Lively has filed serial sanctions motions. Lively reposted Gottlieb's statement on her own Instagram, a community note on Instagram. Oh yeah, the community note. Attempts to correct the misstatements in Lively's releases by advising Instagram users that Gottlieb's statement, and now they're quoting the community note, contains cherry-picked information from the federal judge's ruling, which actually threw out 10 of 13 of Blake's claims, the core one being sexual harassment. The judge found that many of her claims of sexual harassment also did not rise to that level, and that the behaviour in question was part of normal improvisation expected for that kind of scene. This post also ignores the fact that Blake had in fact kissed Justin Baldoni without his consent. In any event, the press releases of Lively and her surrogates are relevant in that they demonstrate the common practice of using public relations statements by parties and their counsel to shape public opinion, the very conduct that is the predicate for Lively's retaliation claims. The aftermath of the statement also demonstrates how much material spreads on the internet organically with no interference or manipulation. Yes. Most importantly, the statements provide material to examine and impeach Lively at trial. For instance, Lively, both directly and through her counsel, makes statements about the facts of the case and her subjective beliefs. To the extent Lively provides inconsistent testimony at trial, her public statements are properly used for impeachment. Gottlieb's press release also downplays Lively's now dismissed claims by stating that the retaliation Miss Lively faced for privately speaking up for a safe working environment has always been the beating heart of her case. It is why she filed her lawsuit. Defendants should be allowed to examine Lively on the notion that the sexual harassment claims she has most avidly pursued and publicized were not really so important after all. Ouch. Lively's statements provide more legitimate fodder for examination. Lively asserts that physical pain and abuse from digital violence is a threat to women and children. The statement includes vague and unsupported statistics such as purported studies that estimate between 16 and 58% of women have experienced online abuse of stalking, with 97% of gender-based violence service providers reported technology-facilitated abuse in their cases. Lively avers that these issues, which have not been previously raised by Lively or her experts, will be the heart of the case she intends to bring at trial. Taking Lively at her word, defendants have every right to examine or at the very least impeach Lively with her statements and those of her surrogates. Exactly. And I said, the only people in this entire case who have suffered digital violence, other than Justin Baldoni through Nicepool, are the content creators who spoke through social media about this case. Many of them were women. Nearly all of them were women, bar a few, a handful. Nearly all of them were women. Many of those women, including myself, had been very open about, personal domestic abuse or sexual abuse. And we got subpoenaed to silence us. But then she's running around saying, well, I'm the voice of all women. People should look up to me. And it really pisses me off. Okay. Opposition to plaintiff's motion in limine. Defendants should be permitted to present the testimony of non-party Shustiflar to respond to plaintiff's expert and trial argument that defendants were responsible for boosting the insensitive Little Bump interview with Lively. Defendant's witness list includes entertainment reporter Shustiflar, who will testify about her interview of Lively and Fla's republication of that interview in 2024. The 2016 interview went viral as a result of Lively's derogatory little bump comment to Fleur. Lively was visibly pregnant at the time of the interview. When Fleur noted Lively's little bump, Lively flashed back with a nasty comment on Fleur's little bump. Fleur, however, was not pregnant, was highly offended, and made her extreme displeasure known in her posts. The remark, coupled with Lively's huffy demeanour, provoked substantial public criticism of Lively's mean girl attitude and insensitive, tone-deaf response on Fleur's comment. Lively has cited the August 2024 resurgence of the Fleur Little Bump interview as evidence of defendants' alleged efforts to seed the internet with negative stories, implying that defendants and their counsel were behind the republication and/or amplification. Lively's own online manipulation expert Aaron Colutter mentions the Little Bump video 43 times in his expert report. He mentions Fleur by name 10 times. Colutter's entire YouTube opinion is based solely on the Little Bump video. In addition, Lively's second amended complaint cites articles regarding the Little Bump video to support her allegation that nearly decade-old interviews of Miss Lively were surfaced, commented on her tone, posture, diction, and language, implying that defendants were somehow responsible. Nevertheless, Lively seeks to exclude Fleur's testimony and evidence relating to the Little Bump interview. Lively first argues that the testimony lacks any tendency to make a material fact more or less probable and is inconsequential to Miss Lively's claims. Quite the contrary, the Little Bump incident is relevant to Lively's reputation before it was allegedly damaged by the Wayfarer defendants. Fleur will provide the jury with a full explanation of the incident, Lively's demeanour, and Fleur's public response. Fleur's testimony also tends to defeat Lively's claims that defendants or their agents seeded the negative content that appeared on the internet beginning in August 2024. Fleur will testify that defendants were not in any way involved in her decision to republish the Little Bump interview in or about August 2024, and in fact that she never had contact with the Wayfarer defendants, their counsel, or their representatives. She will explain that after seeing stories about the rift between Lively and Baldoni that surfaced in the July-August 2024 timeframe, she made the spontaneous decision to contribute her own negative experience with Lively to the conversation, and that the story went viral organically, not because of any influence exerted by the Wayfarer defendants or their representatives. Fleur's testimony provides evidence that is highly relevant to two aspects of Wayfarer's defense, in that it will show Lively's pre-existing reputation, that her mean girl, tone-deaf reputation was attributable to Lively's own high-handed conduct, and that Wayfarer and its representatives were not involved in spreading or encouraging the Little Bump story that contributed to negative reputation. For the foregoing reasons, defendants respectfully request the court deny each of plaintiffs' motion in limine in their entirety. Okay, so there's Ellen. Well, that was really good. I enjoyed that. Let me know what you think. I thought they made great arguments, actually. I completely changed my mind on the net worth. And I mean, I think that I was a bit shocked that they were trying to stop Shusty from speaking. But a bit of me was a bit like, well, I can see Lively's arguments that, how can Shusty testify that defendants had nothing to do with amplifying, right? Even if they weren't in contact. Lively is saying, well, hold on. Melissa Lathan actually took the video, passed it to Jed, etc. And they were talking about boosting it. Now, I have also countered that because the same day, the Daily Mail ran an article, and it was actually the Daily Mail article that Melissa Lathan forwarded to Jed Wallace. And I made the point, well, the Daily Mail is a huge publication. How do we know that didn't bring in views, to Shusty's video? It probably would have. Every time I've been mentioned in the Daily Mail, I've had a boost. So that's what happens. So but I can sort of see, like, I can see what Lively's saying is, well, yeah, but how can Shasti Fla testify that, definitely 100% that it wasn't the defendants who had anything to do whatsoever with the amplification? And it's going to be a struggle for her to do that because she can't speak to it because she doesn't know. No one knows. It's going to be Wayfarer that have to make the argument, well, hold on a minute. No, it's going to be down to the experts as well. But I do think that Shasti should get to, go and testify to her, to the experience, what it was like on the day, what Lively was like. And, there is more. She may even be asked about the time that Lively, got her, because her partner, Magnus, is also a journalist, and he interviewed Lively for a simple favour. And Lively had him drinking alcohol. So the interview became completely useless because, you're not supposed to have alcohol on anything that's televised in, I think it was Sweden. I want to say Sweden. I know Shasti's Norwegian, but I'm sure Shasti said it was Sweden that alcohol is not permitted on anything that's televised. And Lively sitting there making this poor man drink aviation gin. It was in the morning as well. She wasn't drinking it, but that was Shasti's partner. Could she be asked about that? Who knows? Probably not, because it technically is hearsay. I do think there is one weakness to Shasti testifying, and I'm just thinking as putting myself in the attorney's positions here. Is that Lively's side are gonna say, well, you've made a lot of money out of this now, haven't you? You've got a whole side business. You sell merchandise on Etsy, etc., etc. And that is true. That is true. And Shasti has made very public comments that she does not like Lively, does not believe Lively, all very, very sound reasons for it. So, I've got no problem with that. I've done the same. But on the stand in front of a jury, Lively's team will attempt to spin that as, well, you just don't like Lively, do you? So you're here saying all this stuff about her, and it's your personal opinion. That's how they're going to spin it. It's going to be, I'm hoping Wayfarer will prep again well to try and counter some of that. But it is incredibly important because Lively keeps putting Fla at issue here. She put her into the New York Times article and implied that that Fla was working with Wayfarer. She then had to backtrack on that in the Rule 56.1 statement and admit that there was no evidence, and no, she was not actually working with Wayfarer. So hopefully Wayfarer will show these two contradicting positions, where initially Lively was accusing Fla of something which she later admitted Fla was not involved in. Because if you can apply that kind of argument to a non-party, the next statement I would hope Wayfarer would say is to the jury is, so what is it to say that you haven't done this to each of the defendants or former defendants? And that would be quite strong. That would be quite a strong argument. Okay. We have the opposition to the motion for summary judgment. I don't know if the motion for judgment on the pleadings is there, actually. I'll have to go and look. But I think I'm going to do the motion for summary judgment next. Thanks for watching, guys.